Welcome to Company Law and Secretarial practice classes. In today's session, I am going to discuss you about the appointment of liquidator. So let us see what is liquidation. Liquidation is the process by which company's assets are realized, its liabilities are settled, and any remaining assets are distributed to shareholders. Here, liquidators are appointed to oversee the process of winding up of a company. In our mind, the question will arise us, who can be appointed as a liquidator? To be appointed as a liquidator, an individual must meet specific qualifications and authorized to act in that capacity. Generally, liquidator must be licensed insolvency practitioner or independent or no disqualifications. In that first one, licensed insolvency practitioner. It means in most jurisdictions, liquidators must be licensed or authorized by a regulatory body. This ensures they have the necessary skills, knowledge and experience to carry out their duties effectively. Second one is independent. The liquidator must be independent of the company, its directors and its creditors. This is crucial to ensure impartiality and fairness in the liquidation process. Any prior relationship or conflict of interest must be disclosed here. Next, third one is no disqualifications. Actually, certain individuals are disqualified from acting as liquidators, such as those who have been convicted of fraud or dishonesty, or those who have been declared bankrupt. Then let us see the appointment process. The process of appointing a liquidator varies depending on the type of liquidation. Actually, there are three kinds of liquidations are there: members voluntary liquidation, creditors voluntary liquidations and compulsory liquidation. In that first one, members voluntary liquidations. In members voluntary liquidations, how that process of appointing a liquidator is going on in that. First, the shareholders resolution. The shareholders pass a special resolution resolving to winding up the company voluntarily and appointing a liquidator. After that, the directors make a solvency statement declaring that the company can pay its debts in full within a specified period. After that, the appointed liquidator accepts the appointment and takes control of the company's asset. Next one is creditors voluntary liquidation. Here, the directors convene a meeting of the company to consider placing the company into liquidation. Next, notice of the proposed liquidation is given to the creditors. Then a meeting of creditor is held to consider the director's proposal. Then directors nominate a liquidator. Creditors can either approve the director's nomination or nominate their own liquidator. If creditors nominate a different liquidator, their choice prevails. Okay. Then appointed liquidator accepts the appointment and takes control of the company's assets. Under compulsory liquidation, first creditor presents a winding up petition to the court. Then the court hears the petition and if satisfied that the company is insolvent, makes a winding up order. Then initially the official receiver, means a government official, becomes the liquidator. Then the official receiver may convene a meeting of creditors to nominate a liquidator to replace them. Then finally, if creditors nominate a liquidator, the court will usually appoint that person. If no nomination is made, the official receiver remains as liquidators. Okay, these are the procedures. Next, powers and responsibilities of liquidator. Once appointed, the liquidator has significant powers and responsibilities. So in that first one is taking control of assets. The liquidator takes control of all the company's assets and records. Next one is realizing assets, means the liquidator sells company's assets to generate funds. Next one is investigating the company's affairs. The liquidator investigates the company's affairs to identify any potential wrongdoing such as fraudulent trading by directors, anything. Next one is adjudicating claims. The liquidator assesses and adjudicates claims from creditors. Then liquidator distributes the realized assets to creditors in accordance with the statutory order of priority. Then reporting to creditors and shareholders. The liquidator provides regular reports to the creditors and shareholders on the progress of the liquidations. Then the liquidator must comply with all relevant legal and regulatory requirements. Next, finalizing the liquidation. Once all assets have been realized, they are distributed and all outstanding matters have been resolved, the liquidator applies to the court for the company to be dissolved. So these are the books I have referred. Thank you.